Buenas and Day. This public hearing is now called to order, and the time now is 2:03 p.m., Friday, September 12, 2025. This hearing is conducted by myself, Senator Telo Taitague, Chairwoman of the Committee on Economic Investment, Military Buildup, Regional Relations, Technology, Regulatory Affairs, Justice, Election, and Retirement. Today's hearing is a continuation of the public hearing held yesterday at 2 p.m., which was temporarily recessed due to the convening of special session. I'd like to thank everyone for their patience and, of course, their flexibility as we resume our discussions. I would also like to recognize those who are here in person and those who are watching from home. Welcome to your Guam legislature. I'd like to also welcome my colleagues who are here joining me today. Of course, Vice Speaker Anthony Ada, as well as Sean Eugene Gumatao. Thank you, gentlemen. I know it's been a very long morning today, and appreciate you being here. Colleagues, also, the copies of the legislation and documents received ahead of this hearing can be accessed through the Google Drive link, which was emailed to you in advance. For the listening public, you can find the legislation on the Guam Legislative website at guamlegislature.gov. And if you need assistance, please feel free to call the legislature at 671-472-3465. Before I begin, I would like to set some rules of engagement during this public hearing. When you speak, I ask that you please speak directly into the microphone, and for the record, please state your name and position and who you represent. I ask that those who are testifying today to stay seated for any questions my colleagues may have, and then you'll be excused once you have testified. I respectfully ask that we conduct ourselves professionally and respect each other's opinion. Those individuals who do not comply to these rules will be removed from the room and prohibited from further participation. The following bills on the agenda for discussion this morning is, or this afternoon, may I say, is Bill number 63-38 COR, introduced by Vice Speaker Tony Ada, an act to add a new 7146.1 of Chapter 7, Title 16, Guam Code Annotated, relative to transfer on death beneficiary designation for motor vehicle. The second bill is Bill 157-38 COR, an act to amend 25.25 of the Chapter 25, Title 9, Guam Code Annotated, relative to adding stronger penalties for crimes of the third-degree criminal sexual conduct committed against younger victims. Then we have Bill 162-38 COR, an act to amend 19-50, point 50 of Chapter 19, Title 9, Guam Code Annotated, relative to adding fines and stronger penalties to terroristic conduct, including bomb scare threats. So at this time, I would like to recognize the author of the legislation on Bill 163-38. And before I begin, we received a fiscal note for this particular bill. And 163. It was, yes, the bill received a fiscal note on July 14, 2025. We also invited the Department of Revenue and Taxation. We've invited Judiciary of Guam, Office of the Attorney General, Public Defender Service Corporation, the Guam Bar Association to be here. We also provide this for legal to review our legal counsel, and the council had no recommended changes or amendments at this time. And as I mentioned, we had the invite sent to the following agencies that I said prior. So at this time, I would like to recognize the author of the legislation, our Vice Speaker, Senator Tony Ada.
Thank you, Madam Chair. Madam Chair, 163-38 COR. Currently, there is about half of all U.S. states that allow for transfer on death designations of the ownership and title, certificate of title for their motor vehicles issued in such states. The rest of the states allow for a simplified transfer of death of motor vehicles that allow owners to bypass the probate estate and to transfer their vehicles upon death. This bill has many elements in common with the laws of the states of Texas and California. And unlike other types of transfer on death processes, this bill will create a mechanism that should make designating and changing beneficiaries as simple as changing the beneficiary on a life insurance policy. It is intended to be done without the need to hire a lawyer. This bill would not affect transfers from one spouse to another under Guam's community property laws, nor would it affect joint ownership where the vehicle passes to their surviving spouse upon death. Spousal owners and joint owners, however, will be given the opportunity at any time to jointly designate and change beneficiaries. This also does not forgive any liens placed on a car by financing institutions. I look forward to the testimony of the Attorney General's office and anyone else who will be testifying on this bill and any suggestions for improvement. I think, Madam Chair, that this is one of those types of laws that when you see what everyone goes through, especially those that are single or they don't have family here, that it'll make it such an easier process that they can leave their vehicles with someone else who they've deemed that would be a beneficiary for it. And this would, perhaps this may also help with the abandoned vehicles that we see on the side of the road, because if I can't have ownership or claim to it, then I'm not going to take the vehicle home and maintain it. And I look forward again to having the testimonies on this bill. Thank you, Madam Chair.
You're very welcome, Senator, or Vice Speaker. And at this time, I'd like to invite the Office of the Attorney General, our Honorable Attorney General Doug Moylan, to the table to testify. And please feel free, I know that you're very busy, sir, if you just wanted to either read the whole thing into the record or just, briefly go over your testimony. But you're now recognized to provide testimony.
Thank you. Good afternoon. Senator Taitague, Oversight Chairwoman Taitague, Vice Speaker Ada, as well as Senator Gumtautau. We do have the written testimony prepared, which is in basic support of the legislation, and I'll just read it into the record and then be available for any questions that might be there. This testimony is submitted by the Attorney General of Guam on behalf of our client, the people of Guam, in support of the adoption of Bill number 168-38, to permit vehicle transfers by title designation. The law has the potential to assist many of our citizens in finding an easier way forward following the death of a family member. This law already exists in many states, and we believe any concern lenders, real estate professionals, and title companies may have or previously dealt with. After a home, the second most valuable asset of most people are their motor vehicles. The law builds on an effort in American law to design ways to pass property from spouse to spouse or spouse to loved ones without the need for probate, courts, and lawyers. By simply designating the next owner of one's vehicle on the car title, Guam residents will not have to wait months for court hearings to take title to a car or truck. When a loved one passes, one of the first logistical issues include the bank account and obtaining insurance renewals and re-registrations for a vehicle. Oftentimes, the family must scramble to arrange, find, and pay for a probate attorney. Getting an attorney and the court probate slows the administration by the deceased family members to resolve all the real and personal property legal issues. The car is property not conducive to waiting for months, if not years, of property disposition issues in our courts. Letting a car sit in a garage or in open not just makes it useless, but will likely deteriorate it faster. The Guam legislature has passed numerous exceptions to the requirements of court probates. Your Bill 163 is consistent with easing the property administration required upon a person's passing. The new law makes clear that persons taking a vehicle via transfer on death title do not get the property free and clear of lender liens. The car is still subject to being repossessed upon if the car loan is not paid, but now it will have someone able to drive and maintain it, as well as drive it legally with renewed insurance. I would also include a requirement that the Department of Revenue and Taxation provide summary information of the law upon anyone transferring title under this law if passed. Most of us lead simple lives with only a few valuable assets. Bill 163 gives our people a practical, low-cost way to ensure their vehicles pass directly to the loved ones they choose without lawyers, wills, or probate. It eases a common burden during a difficult time and brings Guam in line with best practices already adopted across our nation. Thank you for the opportunity to comment on this legislation.
Thank you so much, Attorney General. If there's no one else, I'd like to open up to the panel. If there's anyone, or my colleagues, No questions from the Vice Speaker. Senator Gumatauta, do you have any questions?
Yes, thank you, Madam Chair, and thank you, Attorney General, for being with us today. I just have a few questions, if I could. Recognizing that the term motor vehicle as used in the bill is defined by 16 GCA Section 1102S as a vehicle which is self-propelled, including a bicycle equipped with a motor and electric personal assisted mobility device, is it necessary for the bill to either define the type of motor vehicles that is to be covered or include all personal and commercial vehicles that are covered in 16 GCA Section 1102?
I think what you just said there, just reference the section of the category of vehicles to the section number earlier would probably be the most efficient way to do that versus redefining anything. Because I think the intent is clear. Usually vehicles that are owned by individuals.
Okay. And then only one other question, and it's building on one of the questions that I raised during a public hearing on an earlier transfer on death deed proposal earlier this year, and with respect to the section of the bill that holds a beneficiary responsible for any contract or sale, assignment, or ownership or security interest to which the owner or the owners of the motor vehicle were subject during their lifetime.
Right.
What information could you possibly share, if you could, that you might be aware of maybe any other U.S. jurisdictions where beneficiaries lose a motor vehicle because they were unable to assume the financial obligations that were tied to those assets?
So the vehicle is normally it's the security for the note, the promissory note that the deceased would normally be associated with. And the banks use the car, and there's a lien on the certificate of ownership, right, that Revenue Tax keeps and is noted. And you normally can't get that released unless you get the bank release form, submit it to Revenue Tax, and they take it off the official title to the vehicle. So, as indicated, what would normally happen is that although your registration may change under the law automatically and quickly, the loan, the promissory note, is going to have to be satisfied. Otherwise, you're either going to have a notice to forfeit the vehicle, it's going to be sold, pay the loan, forfeit the vehicle, or the repossessed company, the possession company is going to come in and take the car. And that's what happens in different circumstances, and you see it in the newspaper where they're putting, these vehicles are being auctioned off in order to satisfy the promissory note. This does not interfere with that security interest that the lender, the bank, or whoever has on the title of the vehicle.
Okay. All right. Thank you so much for that, Attorney General Moylan. That's all the questions I have, Madam Chair. Thank you again for the time.
You're very welcome, and thank you. I support this legislation. I think when we passed another legislation about property or land on, the transfer on death, I'm finding out that land management is overwhelming, full with people wanting to fill this document out and register it at Department of Land Management. If that's the case, I'm pretty sure that Revenue Tax, which I'm hoping would come back with us. And I have a message here. They said, Revenue Tax said that their statement or testimony is forthcoming. But they have not provided it yet. So my concern is to make sure what we're having a problem right now with at Department of Land Management is the correct form on death on benefits. And I want to make sure that we can maybe work together on that and work with what land management has, because everyone's trying to look for this form that they need to take and have it notarized and then file it. It's as simple as that. So if there's something similar to this, then I'd like to ask the author of the legislation that we can maybe find some kind of form to attach to the legislation. And then people can just download it and then take that and fill it out, go have it notarized, and as simple as that.
Yes.
Okay, so other than that, this bill, Bill 163-38, has been duly heard, and would like to also mention that if anyone has any testimonies, those who are listening, you have 5 days to provide your testimony. Thank you so much. The next legislation we have is on the agenda is Bill 157-38, COR, also introduced by our Vice Speaker, Anthony Adam. And this legislation, a fiscal note, was received on July 9th, 2025. The invitations were sent out to the Office of Attorney General, Judiciary of Guam, Public Defender Service Corporation, the Guam Bar Association, and the Guam Police Department. Legal counsel from the legislature has reviewed this bill and said there are no recommended changes or amendments at this time. So at this time, I'd like to recognize the author of the legislation. Vice Speaker Adder, you are recognized.
Thank you, Madam Chair. Bill 157-38 COR is an act to amend subsection 25.25 of Chapter 25, Title 9, Guam Code Annotated, and this is relative to adding stronger penalties for crimes of third-degree criminal sexual conduct committed against younger victims. Madam Chair, on Guam, the age of consent is 16. It means that under Guam law, any person that engages in any sexual acts with a person under the age of 16 commits a crime. The vast majority of states have ages of 16, 17, or 18 as their age of consent. They recognize what mountains of research and evidence have revealed, that younger people are more easily victimized and coerced by adults to engage in illicit sexual activity. In the 36th Guam legislature, I authored Public Law 36-17, which prevented judges from using the Justice Safety Valve Act to waive minimum penalties for sex offenders convicted of first and second-degree criminal sexual conduct. In the 37th Guam legislature, my colleague, Senator Barnett, authored Public Law 37-98, which added 10 years to the minimum sentence for offenders who victimize children under 12. In the 38th Guam legislature, I authored Public Law 38-16, which upgraded the offense of third and fourth degree criminal sexual conduct committed against victims who are 14 and 15 years old to first and second degree criminal sexual conduct, where the offender has a position of authority over the victim. In the last three legislatures, bipartisan efforts to protect the most vulnerable victims, our children, from predators, being kept them locked from predators and keeping them locked up for a long time. Sexual assault is the most underreported crime in our community and that our community has dealt with. It leaves permanent emotional scars on all of its victims. I assert that although every victim faces severe emotional trauma from these crimes, that there is more emotional trauma when the crime is committed against a child who is 14 or 15 years of age. Additionally, children, by their innocence, vulnerability, and impressionability, make them easier targets for predators. Like most states, Guam has two distinct classes of victims by which sexual offenses are classified. First and second degree criminal sexual conduct for crimes committed against victims under 14, and third and fourth degree criminal sexual conduct for crimes committed against victims over 14. This bill does not change the victimology for criminal sexual conduct crimes. It does, however, create a minimum sentence of 12 years of incarceration if the victim is 14 or 15 years of age. Madam Chair, I'd like to thank you for having this public hearing on this piece of legislation, as this is very important as we continue to protect our youth here on our island. And I'm looking forward to hearing the testimony on the Attorney General on this bill and see how we can keep it strengthened, and hopefully that we be able to pass this into law as well. Thank you, Madam Chair.
You're very welcome, Vice Speaker. And at this time, signed up on the sheet is our Honorable Attorney General Doug Moylan. You are now recognized, sir.
Thank you, Senator Taitague. Hafide, this testimony is submitted by the Attorney General of Guam on behalf of our client, the people of Guam, in support of the intent of Bill 157 to hold accountable the perpetrators of sex crime upon 14-year-old and 15-year-old crime victims. We do have a technical correction here, and at least for the committee to be aware of, that a correction may be in order because of the proposed penalty range of 12 to 25 years imprisonment. It falls outside the range of the statutory penalty allowed for second-degree felonies. Title 9 GCA 8030B provides that the penalties for second-degree felonies shall be between the range of 3 to 10 years for repeat offenders, while 9 GCA 8031B provides that the penalties for second-degree felonies are between the range of 1 to 8 years for first-time offenders. Moreover, this proposed 12 to 25-year range is actually higher than the penalties recently enacted by the legislature for those who commit sexual contact against 12 and 13-year-old crime victims under 9 GCA 25.20b as amended. In addition, the provisions in question also encompasses 14-year-old and 15-year-old individuals who are willing participants in the act but are deemed crime victims by virtue of their age. Under this new provision, an 18-year-old criminal defendant who had willing sex with a 14 or 15-year-old would be subject to 12 to 15-year prison term, but a 30-year-old who violently rapes a 14-year-old or 15-year-old would also be subject to the 12 to 25-year jail term, not a higher penalty. The committee may wish to consider these seeming disparities. It should also be noted that the Sex Offender Registry and Notification, SORNA, specifically exempt from the Sex Offender Registry 18-year-old and 19-year-old individuals who have willing sex with 14-year-old and 15-year-old persons, and that's under 9 GCA 8901D, subsection 8. This is why some states have Romeo and Juliet laws that make consensual sex with 14 and 15-year-old individuals a lower grade criminal offense, i.e. third-degree felony instead of second-degree felony. This appears to be an area of legislative consideration. For these reasons, we recommend that the legislature may wish to consider and to revise Bill 157 so that the penalties align with Guam's criminal code and reflect the severity of the types of criminal activity. Our senators must draw a clear line distinction between consensual conduct among near-age peers and violent sex assaults by adults. You may wish this bill to punish predators who specifically target minors with harsher penalties while avoiding over-criminalizing young offenders under what we characterize as the Romeo and Juliet type circumstances. We thank you for the opportunity to comment.
Senator Gumatauto, do you have any questions?
Yes, thank you, Madam Chair. I only have a couple of questions, if I can, for the Attorney General, and this has to go to the Sex Offender Registry. Regarding the list of convicted sex offenders that is publicly available through the Judiciary of Guam's website, particularly the 7 who failed to register and the 41 others who registered but failed to update their information with the court, what information is available regarding the whereabouts of these non-compliant convicted sex offenders, and what efforts are in place to ensure that victims, their families, and those residing within close proximity to these individuals at their last known location are kept informed of known or potential threats posed by these non-compliant CSC offenders?
You know, Senator, I wasn't prepared to address that particular issue, but that would normally, and I've seen it happen, there's a, you know, people in the community can do some reporting if they're aware of the individual's background. I believe it's a requirement they register with the, is it probation, and that they get cited when they don't update the information. And again, I've seen it happen where we actually charge persons that are not complying with the Sex Offender Registry guidelines. So as to that, I would have to do further research.
Oh, no,
on
and that's good news, Mr. Attorney General. I just think that when they are not complying, and then at least to hear that you guys are all on top of these folks, and I'm sure there are other penalties that can be issued to them. And just one last thing, if I can, between the more than 80 criminal sexual conduct related arrests that was reported in the GPD's Uniform Crime Report back in, this is 2023, and the more than 90 psychosexual evaluations and sex offender individual counseling sessions that's provided by the judiciary, this is during 2023. What is the consensus among your team and the rest of the criminal justice system with respect to policy proposals that should be considered by the Guam legislature in addition to Bill 157 to ensure that justice is delivered to victims while deterring such heinous crimes moving forward to the extent practicable?
Well, I have 2 comments on that. Number 1, it's been my position since the beginning that pedophiles should be life in prison without the possibility of parole for those that are the true pedophiles out there, because the victimization is much more severe when you're dealing with the destruction of an innocent life, so to speak, right? The other one is the, so you have those that are being how'd you say, I guess that's the primary one. What was the other part of your question there?
Talking about how do we help deter it? This is one bill.
Oh, the castration, the idea
Oh, yes, I'm sorry, yes.
Yes, the chemical castration was the second part. In 2000, I believe it's 2024, we transmitted to the Department of Corrections the old statute, and it's gotten to that point now. I think it's at least 4 years old. The legislature required that Department of Corrections pass the chemical castration rules so that we can start implementing on Guam chemical castration. I know that I followed up at least twice with the Department of Corrections for that. It still hasn't occurred. So an oversight hearing on the chemical castration, I would strongly recommend to the legislature and have Department of Corrections come down and ask why haven't they pushed it forward. There were some indications it was coming from Adelup, that it wasn't in their policy directives. I don't know specifically. All I do know is that we drafted the guidelines for DOC to modify as needed. We've provided an attorney to help them with any tweaking that they wanted to do on it. That hasn't been implemented. I am a strong advocate of physical castration also. So that's where we're at. And that law had a sunset provision on it, that it would implement, be in effect for a certain amount of years, and then it would be taken off the books unless the legislature affirmatively adopted it from towards the end of its implementation period.
Well, thank you, Mr. AG. What I'll do is the next opportunity that when I'm meeting with the Committee on Public Safety, I will bring this to their attention, and we can talk about perhaps an oversight. But this is good input. And thank you again for being here and testifying on this bill. Thank you, Madam Chair, for the time.
Thank you, Senator.
You're very welcome. Before I turn it over for closing, I just want to make a couple remarks regarding this legislation. First, thank you for your testimony, Attorney General. We will make note, and during the markup meeting, we'll meet with the author of the legislation to make any kind of amendments to this bill that you explained in your testimony. I greatly appreciate it. But I also like to bring up one of the facts that's the reason why I'm supporting this legislation. I think numbers speak, data speaks for itself. And according to the FY 2025 to 2029 General Strategy for Drug Control, Violent Crime, and Criminal Justice Improvement Plan, violent crimes on the island has seen ups and downs. There was a spike in 2022. Followed by a drop in 2023. But of the main concerns highlighted in this link between drug use and violent crimes, which law enforcement sees as a serious issue, is one that 738 violent crimes were reported in 2023, down from 802 in 2022. Forcible rapes, up 36% of violent crimes last year, with 268 cases reported. Murder cases went down from 7 to, in 2023, from 13 in the previous years. And I also like to point out that sexual assault continues to be a major problem, especially for youths. 268 forcible rapes cases were reported, like I said, in 2023, which is up 49% from 2021. The Healing Hearts Crisis Center helped 101 survivors just last year. Just last year. That's 20% jump from 2022. And what's most alarming is that 59 of those victims were minors, which shows just how urgent the need is for the support of services and the support of this legislation. So thank you, Mr. Attorney General, for supporting this legislation and providing also your input. At this time, I'd like to have the author of the legislation close.
Thank you, Madam Chair, and thank you to the Attorney General for coming out and testifying in favor of this legislation. When we go into the markup meeting, Madam Chair, I'd like to, take the recommendations of the Attorney General and see what we can do to strengthen this legislation so that we can get it onto the session floor and get this passed and become law. So thank you again, Madam Chair. Thank you, Attorney General, for your testimony.
Thank you, Vice Speaker. And if there's no further questions, then I would like to call this bill 163 or 162-38 has been heard. Next on the agenda, and the last bill on the agenda, is Bill 157-38. And this is again introduced by our good Vice Speaker, Senator Ada. And the bill was, a fiscal note was provided to us on July 16th, 2025. Invitations were sent to the Office of the Attorney General, Judiciary of Guam, Public Defenders Corporation, Guam Bar Association, the Guam Police Department, the Guam Fire Department, Guam Homeland Security and Office of Civil Defense, Guam Education Board, and the Guam Academy Charter Schools Council as well. We submitted this to legal, our legal from the legislature, and has said there are no recommended changes or amendments at this time. And at this time, I would like to now turn it over to our Vice Speaker on his legislation for opening remarks.
Thank you, Madam Chair. Just on the last bill, that was Bill 157-38, and this one now is Bill 162-38.
My bad.
No problem.
Okay. My bad.
Yeah.
Thank you for the correction.
You're welcome.
So noted. Okay.
So the 162-38 COR is an act to amend subsection 19.50 of Chapter 19, Title 9, Guam Code Annotated, relative to adding fines and stronger penalties for terroristic conduct, including bomb scare threats. What this bill does, Madam Chair, that if it's enacted, it will expand the definition of terroristic conduct involving bomb scares and will provide specificity for places open to the public. Bomb scares, we all been through them. They force the evacuation of government buildings, shopping malls, and even regular office buildings. Additionally, they divert public safety resources such as fire trucks, ambulances, and police cruisers away from other needs of our community. This bill, if enacted into law, does several things. One, it expands the location definition of the places where the crime applies. Two, it raises the fines to a maximum of $25,000. Three, it places the fines into the Criminal Injuries Compensation Fund. And four, it clears the way for civil lawsuits against offenders by businesses that were interrupted by the crime. And five, it requires payment of fines, not work hours, from service credits. Most people on Guam consider a bomb scare as acts of stupidity. They are costly to the victims, and offenders should be held both criminally and financially responsible. It is my hope that a tougher law would discourage this type of these acts of stupidity. Madam Chair, I think like I said, we've all been through it, and enough is enough. We need to hold those that do these type of conducts to be held accountable, and not just like we said, criminally, but also financially, because of all the financial costs that it costs our government and also the private sector to where these crimes are committed. So I'm looking forward to the testimony of the Attorney General again, and we'll go from there. Thank you.
Thank you, Vice Speaker Ada. And again, this is Bill number 162-38 COR. At this time, I would like, okay, Dr. Swanson, you're there. I have also Peter Alexa Ada, if you'd like to come from the Board of Education to come up as well. And if there's no other person here, I would like to start with the Attorney General of Guam so that if he needs to leave, then he can go after that.
Thank you.
So you're recognized, sir.
Thank you, Senator Taitague. This testimony is submitted by the Attorney General on behalf of our client, the people of Guam, in support of adoption of Bill 162-38. Calling in a bomb threat is a form of terrorism intended to instill mass fear in our community. It creates a reaction that no one can predict. Bomb threats are not a new behavior. In the past, a phone typically began the threat. Communication technology today has exponentially multiplied, now making the phone call one of the many ways to convey threats. Masking one's identity, encryption, and the criminal mind likewise has become even more complex, making it more difficult for we in the law enforcement community to investigate this type of criminal behavior. What has not changed is the understanding that a bad act warrants a bad consequence. From our law enforcement perspective, 100% efficiency must confront each threat for fear that this time it's real. A mass shooter or explosive device might create many casualties. That is the reality we live in today's high-tech and commercialized society, making weapons and destructive devices relatively easily obtainable. Bill 162 focuses upon deterrence. However, some technical clarification should be considered. In proposed section 19.50E, the allocation of fines into 3 funds should be qualified on which funds gets the fine first, second, etc. If less than $2,500, an allocation might occur by the court. You may also want to allow the entity or individual harmed to recover their costs and attorney's fees from persons engaging in terroristic conduct if they sue civilly. Also, we recommend defining the institutions that are included in section 1950D. Moreover, I recommend that any minor 16 years or older be automatically charged as an adult if charged with a violation of this section 1950. Guam law provides charging of 16-year-olds as an adult for first or second degree crimes. And for under that age, the Attorney General may apply to the family court to charge the minor as an adult. All too often, high school students think it's a joke when they communicate a bomb threat. A discussion also about parental consequences for minors engaging in terroristic conduct should begin. Basically, seeing what is the legislative pulse temperature for bringing the parents into criminal liability or civil liability when their kids are doing this type of behaviors. We support your efforts to modernize Guam law in line with technology and growing injury to crime victims from terroristic conduct. We also urge that upon passage of this bill, that the Guam Department of Education make as part of their civics or government curriculum education techniques and awareness of why this behavior is wrong and the consequences. Thanks for this opportunity to comment.
Thank you so much. I do know your time is very pressing, so if I have my colleagues, I'm going to ask if you have any questions for the Attorney General. Men? Okay. So you may be excused, and thank you so much for taking the time to be here for this. Thank you.
Thank you.
And at this time, we would like to recognize Dr. Swanson, the Superintendent of Education. Sir, you are now recognized.
Good afternoon, Madam Chairman, Senators. I appear before you today in support of the bill and like to provide some additional information. The packet you've received has the first 2 pages is the testimony I'm going to provide to you, but the rest of it is source material and actual statistics based on our experience with Guam Public Schools in the last several years. Thank you for the opportunity to provide testimony on Bill 16238. Acts of terroristic conduct in the Guam Department of Education are not at the top of the behavioral infractions committed across all 41 or now 39 campuses, but it is a behavior of severe impact to school operations. Attached for your reference is a 5-year data trend involving adjudicated, that is, students found responsible for terroristic conduct and offenses, including bomb threats derived from our data system, Power School, that tracks all student information. In 2020, the department adopted the definition of terroristic conduct provided in section 19.50 of chapter 19, title 19 of Guam Code Annotated. Table 1 shows that the total cases have reduced by approximately 53%. Table 2 shows the same data disaggregated by school and grade level. Logically, most of the offenses are committed in secondary school, with only 1 reported case in elementary. Table 3 further breaks down the data by gender, showing that males are constituted 87% of the offenders. In response to a request from the Guam Department of Homeland Security, the department produced a threat assessment based on acts of targeted violence committed by students from school year 2023 through 2025. Also attached is that document submitted on May 16, 2025. The data presented is a combination of information from PowerSchool, but also a Google survey sent out to school administrators. One of the questions posed to school administrators was the number of bomb threats events that their school responded to during the reporting period. 91.7% responded and indicated 0 bomb threats. The GDOE maintains strict policies and procedures against serious behavior infractions such as terroristic conduct, a level 3 offense. Board Policy 405 and a Student Conduct Procedural Manual SOP 1200-18 guide school administrators to provide various interventions and consequences involving 1 to 10 days of suspension for possible disciplinary advisory council or DAC hearings to request either additional 10 days of suspension, expulsion, or both depending on the level of impact. Repeated level 3 violations could result in the student being expelled for a duration determined by the superintendent. The department concerns with the proposed definitions of terroristic conduct and references to different mediums, that is, mail, telephone, telegraph, social media, any form of electronic text message or other instrument used in preparation in Bill 1638. This provides more clarity on the different ways terroristic acts are communicated and includes behavior that is more expansive than just criminal acts of violence with an intent to evacuate a building that causes an inconvenience. Even though most acts of terroristic conduct are hoaxes, the extensive disruption of school and instructional time in government and private sector operations exacts a heavy financial cost, endangers the community, and unnecessarily burdens first responder assets. As such, the classification of terroristic conduct at the 3rd-degree felony with a penalty of up to 10 years in prison and fines ranging from $2,500 to $25,000 are appropriate. What is unclear with the proposed language is how that will impact students under the age of 18. The language is clear as it pertains to adult behavior, but if acts of terrorism are committed by juveniles, will the parents or guardians of the offender assume responsibility? Would a juvenile be remanded to the Department of Youth Affairs up to 10 years? How would offenders secure financial resources to cover hefty fines? I would recommend that adding language that speaks to this issue so there is no ambiguity in its application. The department appreciates the prohibition of using community service hours in lieu of monetary fines. Often the most powerful deterrents are those that impact the pocketbook. If perpetrators know that they will have to incur a heavy financial burden, they may think twice before committing the act. Bill 16-38 is an important step in enhancing the efforts to curtail acts of terroristic conduct in Guam. It is our hope that all the senators of the 38th Guam legislature will see the value in this bill and unanimously pass it into law. Again, thank you for the opportunity to submit testimony in the bill. Thank you.
Thank you, sir. And at this time, I'd like to recognize Board Member Peter Alexis Ada.
Good afternoon, Madam Speaker, Madam Chairwoman, Senator Ada, and Senator Gumatauta. My name is Peter Alexis Ada. I'm a member of the Board of Education, the longest. I'm hitting 50 years come April or sometime at that time. Anyway, I am also the chairman of the Health and Safety Committee within the Board of Education. I come before you this afternoon in support of Bill 162 with a few suggestions. You'll be shocked with some of the things that I will be discussing. Bomb threats is a disruption. Bomb threats are usually done by in-house students or someone associated with the school. This has to stop. Parents have to know what their children are doing inside their home and outside. It is their parents' responsibility. During my teaching years in both public and non-public schools or private schools, I have experienced something that caught me by surprise. Guess who comes to the parent-teachers conference? It's the parents that you don't need to meet. The ones you need don't show up. And there are many, many excuses. They don't have a ride, it conflicts with their work, and those excuses don't seem to be acceptable as far as I am concerned. DOE currently has a policy to this effect. However, it found that the Kohlers suspension, if they're caught, suspension doesn't work. They need to feel it. I am suggesting, hear this, have the parents shadow their children for 30 days from the moment they walked into the campus of the school, into every classroom, into the restroom. If it's a man, then we'll get somebody from the school to accompany a male or a female, even to the lunchroom, and then as they exit, the parents must be there. The kids won't like this, I promise you that. If they are found to be guilty, I have a suggestion, and this is something you really have to consider. If they are under public assistance, I haven't yet figured out how I'm going to address this if they're not in public assistance, but we must inform public assistance, be it GURA or public health, of the offense that the individual or the house participant has done. And there are two options to this, Madam Chair. Warning or dismissal of the public assistance. But there's another concern, since you're already working on this, senators, on topic of student behavior, and I have another issue that I hope that you can somehow address it. Damaging of public property. It should be whoever has done it, repair it to replace what has been done prior to the damage. We should note, loud and clear, so there's no misunderstanding, there are many, many good parents and students, but there are also a few that need guidance. Thank you so much, Senators, and I really hope that we can address this issue because it has really caused a lot of disruption. As Senator Ada said, not only in the classroom, but including other places such as malls, even the court. And this has to stop. Thank you.
You're very welcome. Thank you so much for your testimonies. And at this time, I'd like to open up to our colleagues. Senator Gumatauta. No questions? Anything on, okay, so I'd just like to make a few comments. And just to let those who are listening, not only did we have the support of the Attorney General as well as yourself, Department of Education, and the board, we also received testimony from the Guam Police Department as well, GPD, and they are standing in a strong support of Bill 162-38 as well. And then we also received from Guam Homeland Security Civil Defense, Esther Agagi, which she also stands in support of Bill 162-38 COR. They have no objections to the bill, but as introduced, we respectfully recommend one amendment for clarity and placement, and that is on page 2, line 10-12, delete subsection D. Instead of add a new section amending 43.31 of Chapter 43, Title 9, Guam Code Annotated, Crimes Against the Community, to read as follows. A person is guilty of a crime against the community if that person knowingly takes, obtains, or exercises unlawful control over government-owned, leased, or borrowed property, or interferes with, obstructs, or takes action regarding government service in such a way that willfully makes any threat or conveys false information in such a way that, one, doing so creates a threat to the public health and safety, or doing so results in the deprivation of public services such as unity services, the education of public, utility services, the education of public and private school students, or any government services intended to benefit the public, and 3, does so for a purpose other than original purpose for which the property or services were to be provided. So we will work with the author of the legislation to provide. I'm pretty sure that I'm hoping you have some of their testimony. If not, I'll be glad to provide it to him. But other than that, at this time, I'd like to now turn it over to the author of the legislation, Vice Speaker Tony Atta. You're recognized.
Thank you, Madam Chair. I'd just like to thank Dr. Swanson and Board Member Peter Alexis Atta for their testimonies here today in support of this legislation. Again, it's important that we hold those individuals accountable. And like we said, no work hours any longer. You pay it from the pocketbook, and I believe that's where they'll feel it. And hopefully these terroristic conduct will end. We'll be able to put an end to them. Thank you, Madam Chair, for having this hearing today, as we were supposed to have it yesterday, but you were able to accommodate me on this date. Thank you.
Absolutely, it's important legislation. So if there's no more questions or comments, this bill, Bill 162-38, has been heard. My office will also continue to accept written testimony on today's public hearing within 5 business days from today, which can be mailed to my office at 238 Archbishop Flores Street, Suite 407 of the DNA Building, Hagatnya. Or you may also send your written testimony to my office via email at senatortelot@gmail.com. Thank you for all your participation today, and create a great day. The time now is 2:56 p.m. This public hearing is now adjourned.